Good afternoon. Sorry.
Let me introduce the case and then you can get started. This case concerns a disciplinary matter involving a Pennsylvania attorney. The attorney involved, Mr. Pisanchin, was hired to pursue a bad faith insurance claim in federal court, which ultimately resulted in an award of $100,000 for his clients. Under the bad faith statute, a court also has discretion to award attorney's fees and costs. Accordingly, Mr. Pisanchin's firm prepared a fee petition complaining reimbursement for over $900,000 in attorney's fees, and this petition was presented to the court. On August 29, 2017, the Federal District Court denied the request for attorney's fees in its entirety, finding that the request was outrageous and abusively excessive. The Federal District Court also directed that a copy of its opinion be served on the Pennsylvania Chief Disciplinary Counsel. The respondent here self-reported the opinion to the Office of Disciplinary Counsel on the date of its issuance. The Disciplinary Board of our Supreme Court ultimately determined that the respondent violated Pennsylvania Rule of Professional Conduct 1.5a, which prohibits attorneys from collecting a clearly excessive fee. As is relevant to this present argument, the board found that pursuant to the doctrine of collateral estoppel, the respondent was precluded from relitigating whether he sought an excessive fee during the disciplinary proceedings because the federal court had already determined that the fee petition was excessive. The Office of Disciplinary Counsel also argued that the respondent violated Rule of Professional Conduct 8.4d, which prohibits an attorney from engaging in conduct that is prejudicial to the administration of justice. After taking into account various factors, the board recommended the respondent be suspended from the practice of law for 90 days. This court is entertaining argument concerning the use of collateral estoppel in this disciplinary matter, the applicability of Rules 1.5 and 8.4, and the consideration of certain aggravating factors and whether the suspension is appropriate under these circumstances. And I'm going to remind counsel that to the extent that there is a concern for disclosure of any confidential information during this argument, your best prevention against doing that is to submit those arguments on the briefs instead of presenting argument here. You can proceed.
I understand. Thank you, Your Honor. May it please the court, my name is Ellen Brotman, and I have the honor of representing Attorney Michael Pisanchin. I do want to start with the argument on collateral estoppel because while I accept everything that Mr. Burns said, there is one thing that I do disagree with, and that is that the findings in the court's opinion could be evidence even where preclusive use of the opinion was disallowed. Now, our cases, my case and Mr. Burns' case, have some differences. One of them is that the hearing committee in my case denied the use of collateral estoppel and so did not use the court's opinions, both the district court opinion and the Third Circuit opinion, as precluding respondent from arguing that the fee was not excessive. Even though these court opinions came in, they came in under, I think it's Rule 201. The hearing committee took judicial notice of the opinions. The hearing committee took judicial notice of the fact that the opinions were issued, that these orders were issued, but not of the facts included in the opinions, as they could not, because those are hearsay statements not offered for their truth. So that's the one point where I disagree with Mr. Byrne, that the findings in an opinion could come in. I also want to say,
And the disciplinary board and the hearing committee, they noted your objection and did not consider them because of the hearsay issues.
the hearing committee did, it's hard, well, the hearing committee had the opinions and evidence, but let's not forget, the hearing committee dismissed this petition. So in that sense, it means they did not take those, they did not use the opinions as estoppel, and they also did not credit the statements or the conclusions.
But they were accepted as part of the record?
They were accepted as part of the record for the purpose of showing that those opinions happened. That was.
Were they certified court records from Florida?
Oh no, my case is not in Florida. My case is in the Middle District of Pennsylvania.
Were they certified court records though?
I didn't object to them on the basis of authentication. They're.
If you were one judicial notice, the court could have taken judicial notice of another court certified record or opinion, correct?
I agree, but does that mean that they also accept every finding of fact within the opinion as I mean, because that's the same thing as collateral estoppel.
But why, but the board didn't agree with the hearing.
The board didn't agree with the hearing,
Right.
and so the board, so the petition for discipline was dismissed, the board reversed and applied collateral estoppel.
Okay, so that's why we're here.
Right. Yes. Yes.
Okay, so I'm not really that concerned with what the hearing committee did. I'm
Well-
concerned with what the board did and what we should do.
I understand.
Okay.
But the hearing committee deserves deference here because they are three smart attorneys that are appointed by the board.
I'm not saying they don't, but as I understand it, the disciplinary board can disagree with the hearing committee, and that's what we're going to be looking at.
That's right.
And they had a record upon which they could disagree.
Right.
That's right. And so the board did disagree, and they used the opinions as evidence of for the basis of their disagreement. And the other point that I want to make about collateral estoppel is it's clear that case Wetter requires a higher standard of proof than preponderance of the evidence, and I don't think there's any question about that.
Now, why do you think that? Because before the argument earlier today, I would have agreed with you 100% that I didn't think there was an issue that a higher burden of proof was required. But what's the basis for your conclusion that the burden of proof is higher?
My conclusion about the fact that case Wetter requires a higher burden of proof than preponderance of the evidence, it's in the text of the case. So if we go to page 490 of case Wetter, the court says, we conclude that the issues in the two proceedings were in fact identical for collateral estoppel purposes. So you have identity of issue. The basis for the imposition constitutes fraud. The jury in the civil fraud case found that respondent, so identity also of party, in this case the respondent was not acting in a representative capacity, he's acting on his own, committed such acts and utilized, the jury in the civil fraud action found that respondent committed such acts and utilized a burden of proof that satisfies the burden of proof employed in a disciplinary action. The fact that the federal court employed a lesser burden of proof that did not require clear and satisfactory evidence in the damages phase of the fraud action is not controlling. So they're distinguishing between their determination that there's a finding of fraud, and which is made at the higher clear and convincing standard, and their determination and the fact that the court had a civil determination of the precise of funds misappropriated at a preponderance standard. So I think that's really clear that they're saying we can find fraud. We can apply collateral estoppel to the fraud finding because that's clear and convincing evidence.
Well, for discipline, that would be all we wouldn't look at the damages award. We
Right.
would only look at the finding
Right.
of misconduct. That's it's sort of obvious, I think.
I think so too, but the court put it in, and the court distinguished, I think, and said because it was justifying its first use of offensive collateral estoppel, and so it's saying we're limiting our finding to this finding that was made by clear and convincing evidence, and this other finding that was made by a preponderance, that's not relevant to us. That's not part of our discussion. I also, I have also struggled with clear and satisfactory evidence, and have in my arguments as respondents' counsel said, it's more. It is something higher. And the board, in every single opinion that it has issued for I don't know how long, but certainly as of last month, always says preponderance of the clear and satisfactory evidence.
But is there anything you can point to in any of the cases involving attorney discipline applying that standard where the court or the disciplinary board have explained what clear and satisfactory preponderance of the evidence is versus mere preponderance of the evidence?
So I always think of it as meaning, it's evidence that is.
No,
I haven't
Counsel,
seen.
I bet you could come up with a great idea. I'm asking you. I mean, I could say four of us could probably come up with different views about how clear and satisfactory is different from unclear and unsatisfactory preponderance of the evidence. I'm trying to understand, has it ever been teased out? Because it just, again, I'm just kind of applying it as a lawyer. I'd be like, well, obviously you have to have clear and satisfactory evidence. Even in a clear and convincing evidence standard, you can't have unsatisfactory evidence. It wouldn't be allowed. You can't have unclear evidence. I mean, no one would rely on unclear evidence. So,
Well, and I've had exactly this conversation with other lawyers as I've been preparing this argument. But, my position is, as you have generously said, I didn't make this problem, but I also think, what I see when the board is saying clear and satisfactory evidence, what I see is they are saying, this is a due process right. This is your property right. This is your reputation right. This is your livelihood. I'm a respondent's attorney, and it is how we identify ourselves almost.
those
as
are all
lawyers.
good arguments as to why we should go with clear and convincing.
And I'm on board with that.
Okay, well, that's I'm shocked. But you can't point to me to any decision where, I mean, I guess the Commonwealth Court attempted to tease it out, but they were sort of stuck with, again, the gift or the problem, however you want to look at it, that this court created. They said, well, we rationalize it as being a quantum. Well, again, I'm not sure how that does anything, but you can't point us to a single. This is our first opportunity to give meaning to it, if we give meaning to it.
And so the case that I cited in my brief is not. It was also cited by ODC, Commonwealth versus Talley, which is a case about what is the presumption, what is the proof required at a bail hearing, and so it's preponderance of the evidence by clear. It is in Talley, the court interpreted the standard of proof required at a bail hearing as proof that is evident, or a presumption that is great, and the court held that this was its own unique standard, one that lies in the interstices, a word I've never spoken out loud, but interstices, between probable cause and proof beyond a reasonable doubt. It requires both a qualitative and quantitative assessment of the evidence adduced at the bail hearing. So my argument in my brief was, this is just like clear and satisfactory evidence. This is what we're kind of looking at. Something that is, if you look at, okay, we have probable cause, we have preponderance, we have clear and convincing, we have beyond a reasonable doubt. Somewhere in here between probable cause and clear and convincing, we have clear and satisfactory.
But it's not clear and satisfactory. It's preponderance of the evidence by clear and satisfactory.
I agree. And I think I agree with the court that it's confused. I also, I also don't think this is a standard that's been, quote unquote, abandoned, as ODC says. It is something that is alive and well in every board opinion that you approve.
And I guess that's really the question, because that's whose conclusions of law we're reviewing in these situations. Right. Now, we don't know what they mean either, but that's a different issue.
Right.
Let me ask you something. Are you still taking the position that the finding by the federal district court that this was an excessive fee petition doesn't implicate Rule 1.5?
I am.
Although it prohibits an attorney from charging an excessive fee. How is filing an excessive fee petition not a potential violation of Rule 1.5?
So I have two arguments on that. And one is really a collateral estoppel argument, which is that there is no identity of issue here. That the factors that the court is looking at are different than the factors that the board looks at under 1.5. And that's really closely related to my other argument, which is that 1.5 doesn't apply to fee petitions. 1.5...
That's really the argument that I was asking you to get out. The collateral estoppel issue is a little bit of a different wrinkle in this. But what is it about a fee petition that takes it out of the notion of it being a charge of a fee by an attorney? I mean, assume that the hearing committee looks at everything, I mean, without any regard to what happened in the federal court, and says, you know what, a $900,000 fee for $100,000 worth of recovery is charging an excessive fee in violation of Rule 1.5. Why isn't that a tenable finding of a violation of 1.5?
Well, first, so my initial argument on why 1.5 doesn't apply to fee petitions is really a textual one. 1.5 is in Chapter 1, which are all client-related, which all talk about the relationships and the duties that attorneys have to clients. And I know ODC has disagreed with that and says, oh, it talks about lobbying, it talks about judges, 1.12. But all of those other rules, the 1.12, everything after kind of like 1.10, 1.12, sale of a practice, they are all about protecting client interests. They are about avoiding conflicts, and they are about clients. Chapter 1 defines your relationship, defines the attorney's relationship to the clients. So 1.5 is squarely in this chapter. It also speaks to the client relationship. It talks about the client. The client is mentioned in 1.5 9 times. It talks about, like, 1.5 talks about when does your fee agreement have to be in writing? When does it have to be contingent? When can you share fees with another attorney with your client's approval? Under the comments, it talks about the client 20 times, like mentions them 20 times, and says in comment 7, the board's policy in a fee dispute. I think it would be best if I got the language. It is disciplinary board policy that allegations of excessive fees charged are initially referred to fee dispute committees for resolution. So I think really I have strong textual arguments that 1.5 applies to client relationships. Now,
primarily because the client wasn't at all impacted by the fee petition.
I mean, the client loves this.
This was trying to get a party to pay a fee petition pursuant to a statutory fee shifting position.
A wrongdoing party.
Understood.
Right.
But why?
Of course, but yes.
If you say that rule doesn't apply because, again, they weren't seeking to collect a fee from a client, they weren't charging the client it, they weren't seeking to get it from the client, they weren't imposing any burden on the client, they were really petitioning the court for a fee shift under bad faith. Why doesn't this involve, instead of 1.5, candor to the tribunal? Why isn't filing and pursuing and advocating for a clearly excessive fee shift position in front of a tribunal a violation of candor to the tribunal?
Because this wasn't a dishonest fee petition. There was ample evidence that all of the work that was sought in that fee petition was done.
No,
ODC.
I guess what I'm saying is, I understand you have defenses to it. I'm just saying, it seems to me that if ODC was going to prosecute a allegedly fraudulent or excessive fee petition, the one is that is not grounded in law or fact, to a tribunal, because that's where the application is being made. It's not being sought from the client. It's not even the client's not impacted. Why wouldn't 3.3 be applicable to that setting? If ODC wants to prosecute a fee petition, why wouldn't that be the appropriate rule to go under?
I mean, I think it would be either 3.1 or 3.3, but neither of those were charged here.
Well, how about 8.4D?
So I really welcome the opportunity to clarify 8.4D because it's the kind of thing that as respondent's attorney, I see thrown in all the time. You know, you have this violation, that violation, let's throw in 8.4D. And in my brief, I misspoke about the language of 8.4D. I said, I characterized it as interfering with the administration of justice. No, 8.4D requires prejudice to the administration. Right, prejudicial to the administration of justice. Prejudice is a very weighted, strong word in the law. And so what does it require? I mean, look at the cases that I've cited in my brief. Baldwin. We're all familiar with the Baldwin case. That's prejudicial to the administration of justice because 3 people couldn't be prosecuted. So the outcome is radically changed. Then I think Altman is another case that I've cited. That was repeated filings that were dishonest and harmed other people's interests. I think when you're talking about prejudice to the administration of justice, you have to be looking for some kind of conduct that is not just, you made a mistake, you made 2 mistakes, you made 3 mistakes, and you caused the court to work longer.
Why is it not applicable to your client?
Because this is a fee petition. Okay. His first fee petition that he's ever filed. What do the facts show? Okay, it asks for $900,000.
Wait, this is the first fee petition he's ever filed?
First fee petition he's ever filed. First fee petition his associate Lee Albright had ever filed.
Well, I mean, yeah, but he didn't even prepare it. He gave it to an associate who had never prepared a fee petition and then tried to blame her for the egregious mistakes that were made therein. I mean, this is a little bit more than putting the federal district court out for a little bit. The federal district court had to ask a second time for backup to the charges within the petition. I mean, this isn't young attorney, oops. I mean, that's not what this is.
Well, and she wasn't that young of an attorney.
I'm talking about your client.
No, I understand. So, I mean, the attorney that he assigned this fee petition to, which had been practicing for 11 years at that point. And so his first direction was call attorney Mike May, because Mike May has filed a lot of fee petitions. Get him to file this petition. Then my client goes on vacation for a week and comes back, and Mike May hasn't been hired, and the fee petition is being done. And the associate, who is a very capable associate. Look at her resume. Her resume is in here as Exhibit LL. She was...
Can I just stop you right there?
Sure,
this
sure.
was a $900,000 fee petition.
I know.
For I'll say no more. I was going to say, based upon the recovery, but it was a 900,000 fee petition. Any attorney would look at that, I would think, and take a step back.
This is a fee-shifting position. This is a fee-shifting petition, which is also intended to encourage experienced attorneys to litigate cases where recovery is uncertain. They represented these people for 5 years in a bad faith insurance case, which has to be won by clear and convincing evidence. I just want to cite to one case.
Counsel, let me go back, because I still don't feel I've gotten an answer to my question.
Oh, I'm sorry.
With regard to 8.4D, prejudice to the administration of justice. Apparently, you hear Justice Donahue speak about the enormous amount of this fee. Share with me, how is that not prejudice to the administration of justice, and if it's not, why not? As you indicated in the Baldwin matter, as a result of the conduct of the individual, justice was stalled, if not precluded, as a result, and people went to jail as a result of incorrect legal counsel. What is the prejudice to the administration of justice by submitting an inflated fee request?
Well, I don't want to accept your characterization of this fee petition as inflated. I really want to take a step back.
Remove the word inflated. Tell me, $900,000 for a $100,000 return. Tell me how the submission of a fee petition is a prejudice to the administration of justice.
I don't believe that it is a prejudice.
I'm actually trying to throw you
I know, I got it. I got it now, Judge.
Not the answer.
I got it. I have it. Thank you. Yes. I don't think it is. I mean, this on its face, this petition is not facially too much. The case of Neal versus Bavarian Motors, the award of damages was 11.5 times the actual damages and found not disproportionate.
Well, Ms. Brahman, I mean, that kind of gets to, I want to make sure I understand the facts here. The court did not find that the material submitted, I mean, this was a reconstruction, right? This was not you didn't actually have real-time bills. This was a reconstruction.
Right.
And the court did not find that the work was not done, that the hourly rates were unreasonable, that it was a proportionality finding, wasn't it? That that $900,000 for a $25,000 recovery was excessive.
That's not correct.
What was the basis of the trial court's conclusion that it was excessive?
So the basis for the trial court's conclusion was that it was woefully deficient in its lack of evidentiary support. So that's one thing. It didn't have it didn't have timesheets, or it didn't have
well, but you're allowed to do a reconstruction, so you would never have timesheets.
I agree. So the district court found that it lacked evidentiary support. That is not a factor under 1.5. 1.5 does not require that when you submit a bill to a client, you give them your timesheets. And that's kind of why I've had a problem, and I have a problem with applying 1.5 to fee petitions, because 1.5 is designed for fee agreements and invoices. It's not designed for fee petitions. So all of the factors, I think, that the court looks at are not part of 1.5.
Can you just, again, the trial court found it was excessive.
It was vague. Based on,
so it was quantum of evidence excessive.
Yeah.
It wasn't that the number itself was excessive. It was you didn't support it with evidence.
That is how the court got to where they got to.
Well,
the
court also found that for every task was billed at the same rate, regardless of who was performing the task. So
Well-
if you had an attorney who was more experienced and one who was less experienced, they were being billed out at the same higher rate, correct?
Right, so and what the court found about that was that there was no evidentiary support for that rate for any of the attorneys, except for Ms. Albright, who testified at the hearing. But under 1.5, there's no, first,
We're talking about 8.4D now.
okay,
Okay, I mean, we're talking about how this might be, the submission of this might be prejudicial to the administration of justice. The federal district court said it was forced to go through entry by entry, all of the amounts that added up to the $900,000. There was no evidence that is generally expected to be there of what is customary and ordinary in the area for trying a case of this nature. There was none of that, and so the federal district court had to take its time and go through line by line. I mean, you tell me, is that prejudicial to the administration of justice?
I don't believe it is. I'm going to cite again to Richards versus Ameriprise, which is in my brief. The court said, it is our expectation that a trial court assessing the reasonableness of attorneys' fees will thoroughly scrutinize the specific line items that are challenged, generally evaluate the reasonableness. I mean, I am not saying this was a great fee petition. And sometimes when you're doing something for the first time, it's not the best work, and you're not that great at it. But what the court did here, what the court did in evaluating the fee, that's the job. That's the job. And it doesn't rise to the level. I mean, clearly it's not a best practice, not ideal.
Was there a Rule 11 sanction?
There was no Rule 11. There was no 1927. And that's how this is distinct also from the Pollock case. Think of it for a minute.
Counsel, if you'd like to sum up, we would appreciate it. I think we've covered the highlights, so what else would you like to tell us?
Mr. Pazantian took on this bad faith case. He represented the Clemens against an insurance company that was well funded. They litigated aggressively. It was his ever getting anything out of this case was uncertain. He knew that he had to prove this by clear and convincing evidence. His client said at the end of the case, he treated us like family. He fought for us. If every attorney acted the way he did, there would be no problems. And they would recommend him to anyone. He works for his clients. That's what's in this. What's in the record. He cares about his clients. He takes every case, whether it's a dog bite or a death case, to the mat. That's what we want lawyers to do. There is also very strong evidence in the case that he's very careful with his finances. And I think these are the two things that we care about the most for clients, for lawyers, that they are communicating with their clients, that they're diligent with their clients, and that they're protecting their clients' funds. What he did here was both he and Ms. Albright believed that that fee petition was fine. I realize it wasn't, and the courts definitely didn't like it, but they both thought that they could ask the court to pay them for everything they had done on the case. That's what they were asking for. Pay us for our work over 5 years. And I just want to remind the court that Ms. Albright's testimony, who prepared the fee petition, even though she said a lot of things about how unhappy she was in that job, her testimony was, I prepared the fee petition, I reconstructed it. She testified at federal court and she testified at the hearing. Nothing in that fee petition was unreasonable or unnecessary. It was accurate. So no matter how much she didn't like her boss, there was no connection between whatever she felt about that job and how she did that fee petition. That evidence was completely irrelevant. It shouldn't have even gotten in. So I would ask the court to reject the board's recommendation.
And just for clarification, may I ask you, it's 1.1, 1.5A, 5.1A, B, and C, and 8.4D? All of them found
That's all that was changed. That's all that was charged. Sorry, all that was charged.
it? Where they found it?
They found nothing. They found,
No.
the hearing committee found no,
The disciplinary.
they just, the disciplinary board only found 1.5. Sorry, got all confused. The disciplinary board only found 1.5.
Got it.
Okay, so,
Thank you. Thank you, counsel. Office of Disciplinary Counsel?
May it please the remaining members of the court.
Still a quorum.
Thank you, sir. I am Disciplinary Counsel Mark Gilson, appearing on behalf of the Office of Disciplinary Counsel. I'll agree to dispense with my opening statement. I don't think that you necessarily need to hear it. I'm sure you have a lot of questions. Going right to the application of collateral estoppel, to answer a question that Justice Robson has posed, in my research, I was unable to find a single decision of either the board or the court that turned on the clear and satisfactory language. Not a single one of them. It appears
What do you mean by turned on it?
in which it was discussed, in which there was any analysis done.
But ODC does in fact state that as the burden.
No, we believe the burden of proof
No,
is preponderance of the evidence.
I'm sorry, the disciplinary board, in its opinions to us, they use the standard, they state the standard as being preponderance with clear and satisfactory evidence.
I think what they've stated is, they stated that the ODC's burden of proof is the preponderance of the evidence by proof that is clear and satisfactory. That language has been around since, I believe, 1936. It has been continuously cited in the board in some of the court's earlier opinions, but it has not been cited or used by this court since 2012.
And none of us, your reason for bringing this up is you have found nothing where either this court or the D board has said the charges were proven here by preponderance of the evidence, but not by preponderance of the evidence by clear and convincing or clear and satisfactory.
Right.
There's not a teasing out of what the difference between those, if there is a difference between those two.
Right, there is none. It appears to be a vestige of a long time ago that has just been repeated that changes nothing. ODC's burden is a preponderance of the evidence. If the court wants to increase that burden to clear and convincing, the court can do that. I don't suggest that the court should do that.
Why not?
Well, I think this Pisantian case is the best example of that. And what happens oftentimes in these cases. There was a sanction imposed here. It might not have been a Rule 11 sanction.
What was the sanction?
The sanction was he was denied any and all attorney's fees, even the ones that the court found he would have otherwise been entitled to. So the district court judge, Judge Mannion, when he went through every entry in that fee petition and authored a 100-page opinion, the court found that Mr. Pisantian would be entitled to certain fees. But then in the exercise of its discretion as a sanction.
Did he say sanction?
Yes. In fact, I think the language is in the Third Circuit in the Third Circuit's appeal, said that this was a sanction imposed for abusive conduct. Yes. This was a sanction imposed for abusive conduct.
So this was, okay, this is really interesting. I'm going to read the Third Circuit decision, but you're basically saying that a federal judge imposed a sanction for violating a state, for engaging in bad faith conduct under the application of Pennsylvania state law.
I don't know if they articulated it that way. What the court said was...
Because the fee-shifting provision is state law. It's under
Yes.
Pennsylvania so this was a federal court applying state law.
Right. The case
federal court said you didn't meet your burden to get your fee petition granted, but on top of that, I am sanctioning you by denying you anything. What authority was there to do that? I mean, I agree the judge had the authority to deny the petition in toto.
Right.
But what authority did the judge have to do that as a, quote, sanction, close quote?
Well, I don't recall the exact authority that it's cited to in terms of the case law. The case was initially initiated in state court, and then it was removed to federal court by the insurer. The district court judge, in his opinion, and it might be it's a 100-page opinion, so
Probably the longest Judge Mannion ever wrote.
Exactly. So if I don't recall exactly the judge's justification for doing what he did, what I do know is that he did find that Mr. Pisanchin would be entitled to certain fees after doing the analysis. And I don't believe that the burden is necessarily on Mr. Pisanchin. It's a question of reasonableness. The court does a reasonableness analysis of the fee petition to decide whether it is in fact reasonable, which, by the way, was something that the Pisanchin firm did not do. And there was testimony to that effect. They used a kitchen sink approach. Every task that was done on this case, regardless of whomever performed it, whether it been a lawyer or a non-lawyer, if it was in their case management system, which was known as Needles, the exact testimony of the associate that prepared the petition was, if this was in Needles, it went in the petition. Once it was in there, nothing got taken out. And there was never a discussion held amongst any of the members of the firm whether a task was reasonable, necessary, duplicative, redundant, vague, lacking in specificity, nothing. If it was in Needles, it went into the petition. So that forced the court to go through the petition line by line and author a 100-page opinion in which it found that some of these tasks he would have been entitled to attorney's fees on. Others it denied because the entry was vague, it lacked specificity, it was redundant, it was excessive.
There are a lot of fee petitions filed in the Commonwealth of Pennsylvania,
Yes.
apparently in state and federal court. Many times they're litigated over detail, vagueness, duplicity, duplicativeness, maybe duplicity, duplicativeness. They're often aggressively litigated. The lodestar fee is too much. There's any number of. I understand the judge's frustration, I guess, but what makes this situation of a failed fee shifting petition any different from any failed fee shifting petition that is vague, is duplicative, because it happens anecdotally, in my experience, not infrequently.
It was the totality of the circumstances, the abuse of conduct. It started at the beginning. Mr. Pisanchin represented his client for 5 years. He knew he was going to be filing a lawsuit under a fee-shifting statute. He had a case management system in place that allowed them to keep track of every task. It would have permitted them to keep a record of the time that's performed on a task, yet they never did. They did not have contemporaneous time records, and I understand you don't have to have them.
It's not a violation of any rule.
No, you don't need
A
them.
lot of people operate that way, and
Right.
it's not necessarily improper to operate that way.
I understand you don't need to keep contemporaneous time records, and you can recreate them.
Did he have a fee agreement with this individual?
Yes, it was a contingent fee agreement. Contingent fee.
In the contingent fee agreement, did he request that all expenses would be paid by the client from the proceeds prior to distribution, or
I honestly
because I guess what I'm trying to get at is this is a fee petition because you're doing it because you're permitted under the under our rules for counsel, Anita counsel. But if this were a private petition or private fee agreement, many times counsel will tell their client, yeah, I could file an action for you. But by the time I get the expert and I get the scenario and I get the video, the recovery is going to be eaten up by my expenses, and you got to pay me my expenses before I even give you your share, which means I could get more money than you can. And some people say, I just want to do this on principle. What's the difference? Those individuals don't go in front of the board as a result of an act that Mr. Pisanchin did, but he's getting paid by the government.
I'm sorry, I'm not quite understanding what's the
The
difference.
comparison, you're saying that he submitted a fee that the federal court said it was improper, excessive, and was sanctioned. Yet, if this were a private fee agreement between client and counsel, with the understanding that this litigation may result in more fees being generated than recovery being obtained.
Right, well, I mean, I think you're talking expenses, the expenses and the cost of litigation.
But also, you're allowed, usually you don't bill for every hour if you're doing it on a contingent fee. It's usually.
No, you don't.
And that's the concern that I have.
Right.
But if they signed agreement and it said this is okay, then I don't know. I'm just trying to find out from you how this played out. He got this client. He was able to sign the fee agreement. On what basis did he get the fee agreement? The client was an indigent, or is it because he went to federal court?
This is a bad faith insurance claim.
Okay.
No, it didn't start, it initially started as an auto accident and I think it was uninsured or underinsured motorist claim.
There's a
But
denial of coverage.
It was a denial
Right.
of coverage.
Right.
And there was so as often happens when there's a potentially low actual damages that you can prove, you would take a case because you can argue it was bad faith refusal to settle or bad faith refusal to pay.
I got it. I apologize. It's a bad faith case.
It's a bad faith case.
Bad faith
You're
case,
right.
Yeah.
Yeah.
I got it.
So, but to Justice Dougherty's point, I think though it still is a salient point is the relationship, and this goes to the point about 1.5. The client was not charged anything other than whatever the client agreed to in terms of the recovery. I would assume, maybe I'm incorrect, that the client here essentially did not claim in the fee arrangement an entitlement to court-ordered attorney's fees.
Well, see, I'm not clear about that either. I've read the fee agreement, and it said that it was like a typical 40% of any recovery.
If you go to trial.
Right.
Right.
If we go to trial, 40% of any recovery, and then it defined recovery to include practically anything. So I don't know if...
So it was actually in the client's best interest then
Yes.
for Mr. Pisanchin to advocate as aggressively as he could for the highest possible fee he could because his client would benefit from a high fee award.
It is possible that if the court had granted the fee petition, the client would have been entitled to some of that money under the fee agreement that was signed. Or in any event, that Mr. Pisanchin would not have taken the 40% contingent fee and the client would have received a greater recovery. That did not happen here. So the client was harmed by the incompetence that was demonstrated here in the preparation of the fee petition. Definitely the client suffered a harm, whether they realized it or not.
Well, you were speculating that the client was entitled to it, and now you're saying this client definitely suffered a harm. So I think I'm not sure I understand the two different positions. Was the client harmed or not?
Yes.
How?
The client was harmed because instead of having the opposing counsel pay the attorney's fees had to be taken from the recovery.
How do you know that the client hadn't already agreed to the attorney's fees being to the 40%, even if there would have been a recovery? You don't know. You don't know it sounds to me like you don't know what the fee arrangement was.
I know what the fee agreement said.
Right.
And the way that it could have been interpreted, and it certainly could have been interpreted to include that the client would have gotten a portion of it included recovery basically from whatever source
What you just
derived.
said, and don't get mixed up in the hypothetical. What you just said was that the client fee arrangement here provided that if Mr. Pisanchin's firm was successful in getting a higher fee award, the client wouldn't have to have paid 40% of the actual damages, the coverage amount.
No, I didn't.
Well, I thought you said that.
I didn't mean to say that. No.
So they were going to pay the 40% of the $25,000 no matter what, or whatever the amount of the recovery. $100,000. They were going to pay They were going to pay the 40% no matter what.
Right.
Well, you're speculating.
But it would have been a higher recovery.
Right. So you're saying the client was harmed by an over-aggressive lawyer.
Yes, well, the client lost out on the ability to potentially recover more money.
And you add the word potentially again.
Right.
So
Well, I hate to even extend this any further, but probably the best that the client could have expected and would have gotten is the return of the 40% of the $100,000 that was paid.
Right.
Otherwise, what we have is an attorney who's actually being paid for all of the time that they put into recovering $100,000. I mean, that's what the fee petition was for. It's not an additional recovery for the client. Let me ask you a question. Along the lines of collateral estoppel, we've already discussed the fact that the district court had to find that there wasn't a reasonable basis for the fee petition. Is that the standard?
For many of the tasks that were listed in the fee petition, the court found that they were not necessary or reasonable.
Okay. What burden of proof did the court use in order to make that determination?
The court did not state a burden of proof, as oftentimes happens when they're doing this type of thing. Under the case law that we cited, when no burden of proof is cited by the court, it would default to a preponderance of the evidence standard. But if you look at Judge Mannion's opinion, it's very clear that it was very comprehensive. It was extremely detailed. It went through every entry of the fee petition, and it resulted in a 100-page opinion by the court. So
that doesn't tell me anything about the burden of proof that he applied.
I would say it was a preponderance of the evidence.
I have a question with regard to the collateral estoppel. You know, generally our court can look at federal court opinions, but they're not, we sometimes refer to them as non-precedential. I mean, we don't have to follow what any federal court says, except if it's the United States Supreme Court, of course. And so here we have a case where your position is that you want us to take and accept the findings of the federal court, which is not binding on this court, and not give the attorney in this disciplinary matter the opportunity to litigate the issue that the federal court found on when we don't know, in fact, what burden of proof they used. And I just am really uncomfortable if we don't accept federal court opinions as precedential opinions in the first place. Why should we wear an attorney in our Commonwealth has their reputation, their ability to work, their license to practice law on the line? Shouldn't that be something that we say, no, we're not going to allow collateral estoppel on that issue? And when we do hear it, we're going to hear it at a burden of proof that's applicable to those types of things where we're looking at somebody's ability to practice and somebody's reputation. And I'm kind of suggesting that it should be clear and convincing evidence as opposed to a mere preponderance.
Well, number one, that did not happen here because the hearing committee did not apply collateral estoppel. So Mr. Presantion, so the ODC had to meet its burden of proof. We had to present evidence. We had to call witnesses. And we did. And Mr. Presantion had a full and fair opportunity to litigate the issue. And he did. He testified and he called witnesses and he presented evidence. And he had an opportunity to argue that ODC had not met its burden or that we had not violated any of the, that his conduct had not violated a rule. I think it's important, though, to point out that when you're applying collateral estoppel, it's only to the factual findings of the lower court. Ultimately, it's up to the board and to the court to determine whether or not those findings violate a rule of professional conduct. So the board and the court...
How is a finding of excessiveness not factual?
Well, I don't... The court did use that language, but it said more than that in making that finding.
What else did it say that is not factual?
It said that, well, it said that the fee petition, the entries were vague.
That's factual.
Right. So those are facts, findings of fact, but it's not a finding that it is necessarily excessive. Or even if it uses the term excessive, it's still up to the board, to the court to determine whether that in and of itself would violate Rule 1.5.
Can I ask you a question about 8.4?
Yes.
Can you give me an example of misconduct by an attorney that does not prejudice the administration of justice?
Failing to communicate with a client may not necessarily prejudice the administration of justice.
Can you give me an example of an attorney's conduct in the courtroom, misconduct in the courtroom, that does not prejudice the administration of justice?
I'm hard pressed to answer that question on the spot.
But there probably are some.
Yeah, I mean, there probably are. Yes, exactly.
I just think 8.4 is interesting because again, I think that we're all officers of the court, and we shouldn't, all of our misconduct potentially impacts on the administration of justice. But I think 8.4 is interesting. This is more of a 8.4A says it's a violation of 8.4 to violate the rules of professional conduct. Is that somewhat redundant?
It is.
Okay.
I don't think I've ever charged 8.4A.
Okay.
Were you trial counsel?
But of course,
Did you try the case?
Which case? The Pisantian?
yes, this case.
Yes, I was disciplinary counsel that handled it.
But 8.4D requires prejudicial to the administration of justice.
Correct.
That's higher than impacts.
It certainly is.
Causes harm, correct?
It certainly is, and I would, to answer your question, perhaps an argument to the court that the court felt was improper isn't necessarily one that would result in conduct detrimental to the administration of justice.
Is raising on appeal a waived issue that is prejudicial to the administration of justice?
Waiving?
Issue. Is raising on appeal a waived issue prejudicial to the administration of justice?
Unless you have a reason why you should be allowed to raise it, and you may have a reason why you should be allowed to raise it, but I would think it could arguably be. It's a case-by-case, obviously, decision that you would make. But in this case, it's fairly clear. This abuse of conduct from beginning to end, failing to maintain this contemporaneous time log. I know you don't need to do this, but you would think that if you're going to be suing under a fee-shifting statute and you have the capability to do it, that you would. Failing to present the evidence in support of the fee petition itself. Getting multiple opportunities by the court to do so in an order that gets issued saying
That's troubling.
Right.
That's troubling.
Present us with affidavits from the lawyers that worked on this case, and they don't present them. Present us failing to present the recreated time records until being told to do so. The court granting a hearing and providing you yet another opportunity to support the fee petition, and then you calling a single witness who you failed to adequately prepare for the hearing, and you failed to meet the burden there. And then the court made its decision, and up on appeal, the Third Circuit affirmed it and made some of the same factual findings looking at the same fee petition, which this court can do for itself. All you really need to do is look at that fee petition, and you will see that it is woefully deficient and that the fees that were requested were outrageously excessive. And I would submit that that is a 1.5 violation. It is an 8.4D violation to force the court to waste its limited resources and time to go through this fee petition, which is something that the Third Circuit mentioned. Yes, most of the time when courts get these excessive fee petitions, they simply go through, do the lodestar, and give the lawyer less than what they ask. But when you do that time after time after time, there's absolutely nothing that discourages lawyers from approaching these things as if it was throwing in everything in the kitchen sink.
What would have happened if Mr. Pisanchek had filed a fee petition that was woefully deficient, that it didn't include all the costs that the client was going to be obligated to pay, that it left an unresolved issue with regard to the fair fee turned? Is that a violation?
It's kind of like if the tree falls in the forest and no one is around to hear it, it doesn't make a sound. Who's going to complain about that?
I'm really asking it because it concerns me that certainly the fee petition was for a lot of money, especially in comparison to the recovery that the client got. But my understanding is that the mechanism to ask for the fee was because it's one of those statutes where you want to encourage attorneys to take these cases, recognizing that they're not going to be compensated unless you have a fee petition. There's going to be a lot of people in our Commonwealth that's not going to be represented on issues because of payment.
I don't think it's that was the reason for the statute. I think the statute is more of encouraging insurers to take on insurance companies, knowing that if they don't have the money, if the attorney prevails, they can get a fee petition. It's not so much that lawyers, I'll agree with you, and that lawyers will take on these types of cases that sometimes don't result in a large settlement or recovery.
So when we start tinkering with that type of a statute and looking at these fee petitions, I wonder particularly where the more he asked for, the greater benefit it was going to inure to the client. Is it really a violation? Is it an area that we should be looking at subjecting our attorneys to discipline?
I believe it is when it's done like it was done here, in this situation. From beginning to the asking for the same attorney's rates for all lawyers, regardless of their background or experience, and submitting a single affidavit from attorney when there was testimony at the hearing that not a single person in the Pisanchin firm had the same background, experience, or skills that the lawyer had who submitted the affidavit.
Didn't they have a guide for the amounts of hourly rates that were published somewhere that they thought they could use?
Yeah, they used the rates that I believe the Philadelphia Community Legal Services. I'm not sure if they relied upon that, more upon the affidavit. I believe the affidavit might have been what they provided to Judge Mannion. They also charged...
So Judge Mannion might have disagreed with that, but it wasn't like they just made up a number. I mean, they did some research to come up with a range of a billable hourly rate.
They came up with an affidavit from a lawyer, but the law requires that it has to be the prevailing rate in the community based on similarly situated lawyers who have the same background, experience, and skills. And they failed to do that here. They also charged an attorney rate for tasks that were ministerial, administrative in nature. They failed to distinguish that. They provided no support for the rate that they charged for the paralegal or for the technician at the time of the trial. I mean, it was woefully deficient in just about every aspect, and the court found and took issue with just about every entry, which is why normally the court would have just simply given Mr. Pisanchin the fees that he felt that the court felt that he had earned, but in an exercise of its discretion for the first time ever in the Third Circuit Court of Appeals decided that as a sanction he was to get absolutely nothing, and the Third Circuit said that was appropriate here because of the abusive misconduct that occurred. And I would submit to the court that has to trigger some rule of professional conduct in terms of attorney misconduct.
But you have to charge a rule of
Right.
conduct.
So we did charge 1.1 because I do believe that it was incompetent the way that this was done. We also charged 5.1 because he did have the associate recreate the time records and prepare the fee petition. She did the draft, but Mr. Pisanchin was intimately involved in all of that.
But before us, you're arguing, as I understand it, you'd want us to uphold the Rule 1.5 violation, but you'd also like us to find that there was an 8.4D violation here.
Yes, that is my argument.
The two that you're arguing, right?
Yes, but your review obviously is de novo. I've always taken the position that it was incompetent too.
Why not a 3.3?
Because I have to agree with Ms. Brotman. I don't necessarily believe that it was dishonest. It was incompetent.
Counsel, would you like to finish up your argument? Are there any other questions from anyone?
We answered everything.
There you go.
I want to thank the court for the time. I am the last person. It's been a long day.
Yes, you are.
We are all tired, and other than that, I just want to say have a good evening.
Okay, thank you. Good argument from both of you. Thank you so much. That concludes our Pittsburgh Spring argument session. And you're free to leave, but before we leave, I would like to make certain that we thank PCN for their coverage today and always, and Of course, our court crier, Brian Minner, and our pathonetary, Caitlin Gorman, our court security, John Evans and Gary Shevlin, as well as the Allegheny County Sheriff's Office. Thank you very much for your security. And Mr. Minner, you may adjourn the court.